right, looks like we've got everybody back. Be back on the record. KCR 2220-838, State versus Lori Vallow. Ms. Vallow is represented by attorney Mark Means. Rob Wood representing the state. Took a break after the first motion we heard this morning. This will be the time now to hear the motion on defendant's declared motion for an order directing attorney-client privileged communications. That was filed on January 19th, and the courts reviewed that as well as the state's response, which was filed on February 12th. Mr. Means, are you ready to present argument on the motion?
I am, Your Honor.
All right, you may.
Thank you, Your Honor. As cited in the motion, I think the Sixth Amendment is applicable here in my client's right to counsel. Furthermore, embedded in the Sixth Amendment is a right to a fair trial and a fair process. And as cited, the case law of a rough equality, our Sixth Amendment requires fairness of rough equality between adversarial opponents. In what we're dealing with here is somewhat, and I can acknowledge, an unprecedented time in what our country is going through. But at the same time, there have to be certain safeguards that have to be in place, especially regarding such a case that receives such public attention. My client has been in the Madison Detention Center since approximately February to February. So we're dealing about 12 months. Over the course of this 12 months, approximately 6 of these months, I have been denied access to my client to visit with her in an attorney-client room. We've had at least 3 recorded phone conversations after multiple representations that have not been recorded, that have been leaked in one way or another. And there's some dispute over this, but one way or another, making their way to the prosecutor's office and or to the detectives for the prosecutor. I will cite that in response of the state, they've referenced a May 9th phone call that I'm not familiar with. That might be a 4th call that I need to look into. Again, issues with attorney-client privilege communications. We're also in the Madison Detention Center dealing with video cameras that are front and back that are recording the communications. There's an entire clear glass wall where deputies are outside able to watch the communication and the interaction between the clients. Anytime I call my client, she has 2 options. One, she can stand at the desk with the deputy, as I cited, with about 2 feet handcuffed to a phone call with the deputy standing right next to her, or approximately 15 or so feet away. She's on a recorded phone line through Tailmate, and obviously we've had issues with that before, cited, I think, by both sides. There's pictures attached to my affidavit that show the circumstances in which I'm having to meet with my client in this situation. And as cited by the prosecution, we have tens of thousands of pages, hundreds and hundreds of gigabytes. And now I am supposed to meet with my client on a recorded phone client line, which I'm being told again is not being recorded, but I was told that before when it was recorded, on a stool about 18 inches off the ground behind 2 inches of glass with a phone that you have to input a code about every 10 or 15 minutes to continue the conversations. This is not, I think, in good faith with the fairness requirements. I think if we clearly look at it and say, if the prosecutor had to prepare his case under these circumstances, they would be complaining about the same thing. Now, what's interesting is if we look at the treatment of Mr. Daybell in Fremont County, which is approximately, if you look at detention center to detention center, about 13 miles away. And Mr. Pryor can speak more to this, but it's my understanding Mr. Daybell's been incarcerated for 9 months. He's had 0 alleged allegations of recorded phone calls, 0 interference with his client privilege communications, 0 denial to see his client, 0 video cameras recording him, and 0 phone calls with deputies around him. This is obviously drastically different when we're dealing with roughly the same facts and the same charges. I think there could be an argument made, and I'm a little concerned with this, that the Madison Detention Center houses the female inmates for Fremont and for Madison's my understanding, and Fremont Detention Center houses the males. We're treating them differently. I think there could be an argument for potential gender discrimination. And again, I'm trying to avoid that in the future, but we do have an issue here with the access or fairness of the process. I have to point out that each of the time that what appears to be arbitrarily denied access to my client to meet with her in an attorney-client room, it coincides with 1, my motion to reduce bond that brought up the recorded phone calls before, and 2, the motion to disqualify the prosecutor. Point out specifically, since filing this motion, the last time I saw my client in Madison, when I requested to see her in the attorney-client room, I was told by the deputies that I have to get an order. And that was it. I objected. I said, hey, look, I want to visit with her. I've had them test me for temperature, wear a mask, sit 6 feet apart. We've complied with all of that. There is no evidence to say we haven't complied with that. And given the extreme amount of information and evidence in this case, it is impossible at this point in time, and given the 6 months that I've been denied, to prepare an adequate defense and to work with the evidence that we have with my client in these circumstances. I've asked for a few things that, in all reality, I really shouldn't have to ask to visit with my client. But given the circumstances of COVID, kind of looking at it from a unique perspective of what we're dealing with here, if the state or the courts are going to allow the prosecutor or detention centers to make restrictions on attorney-client privilege, I think Lady Liberty would require that we also consider making some adjustments to accommodate for those restrictions. What I've asked for here is, one, that I be allowed to visit with my client in the attorney-client room. Two, I've cited the case law, and I think it's well established. Nonverbal communication is communication. Communication between an attorney and a client is protected. These video cameras, they're watching these video cameras. They've been referenced in one or two of the affidavits filed by the prosecution when they complained that I took pictures of the situation in which we are in. They watched these videos. I know that they have watched other videos with my client. I've asked that they be turned off. And thirdly, I think a cell phone provided at the expense of the defense with some severe limitations on the cell phone would be appropriate. There's case law, and the court is probably well aware of this, that there's case law that when a prosecution or the agents of the prosecution have access to recorded phone calls or privileges, that cases can ultimately be dismissed. And what we have here is at least 3, maybe 4, based on the representation here, of some recorded phone calls that in one way or the other, I don't think we have to have that argument today as far as who's at fault, one way or the other has made their way to the prosecutor or to the detectives in this case. If we allow them to continue to have that opportunity after I'm being told that I'm not being recorded, and it happens again, we're going to be in an awkward situation where potentially the case will be requested to be dismissed. And I don't think the prosecutor wants to take that risk. And so in requesting a cell phone, there are now cell phones available today that do not have text message capability. They do not have internet capability. They can be extremely limited to the phone number in which they can access. What we would propose is, one, that the court allow me unrestricted access, as I should have, to my client in the attorney-client room. 2, that these video cameras be turned off. 3, that she be given a cell phone that she can use much like the laptop to review the evidence in this case, limited to my phone number only, no internet access, no text message, none of these type of things, I think, which the prosecutor expressed some concerns over. And it would be my obligation to find and make sure that that happens. If we're able to do that, I think it benefits the attorney-client privilege and makes it more realistic and the ability to prepare a fair defense. And at the same time, it would turn around and alleviate the pressures from the prosecution that in the event that is the recording turned off, is it not turned off, was Mr. Means recorded? I don't want to have to go down that road if we don't have to, Your Honor. So it's somewhat saddening that we have to come and ask the court for this type of order, but I'm being told blatantly and right up front that without it, I'm not going to have access to my client like I should. So we'd ask the court to enter an order to that effect.
All right, I have a couple of questions, Mr. Means. So over this past year, well, let me just make sure I understand the layout of where you're meeting with your client in the jail. So there's, as I understand it, a separate, what they call attorney-client room, where you can have a face-to-face meeting with an inmate. Is that correct?
That is correct, Your Honor.
And then the photograph you showed in your exhibit would be the visiting room, where there are phones and a plexiglass barrier, correct?
Correct. And if you look at the picture of what is behind my client is the room that they use for the attorney-client privilege room. So you have the glass there that shows into the desk of the deputies, and then you have behind that room where the public would come in and visit.
All right. So over the last 12 months, then you have had face-to-face meetings with your client in the attorney-client room. Is that correct?
I have, Your Honor. And then it's and this is where I'm trying to be reasonable here. The coincide with the restrictions is, as I said, is timely with these motions that I filed that I think the prosecutor of the state probably do not like. And I've been allowed, they've tested me for high temperature. They've made me wear masks. They say sit 6 feet apart. And there's been no allegations of any violation of that before. But then specifically back in March, COVID restrictions didn't change. Just all of a sudden, I was told I couldn't go see my client. And then come June 6th, where there was some development in the Daybell property, a phone call was made after my conversation with Mr. Wood that said, oh, they're still doing that. They won't allow you. Let me call them. And I was allowed free access to my client at that time in the attorney-client room. And the only thing that changed was the phone call. Then come January, motion to disqualify. All of a sudden, I can't go in and change. Now, it's my understanding that Fremont County and Madison County are under the same health districts. And we're talking about a 13-mile difference and a drastically different set of circumstances and treatment when it comes to access to the client.
Mr. Means, when did you last have a meeting with your client in the attorney-client room?
Would have been before I don't have the date in front of me, but it was well before January. I would imagine it'd be sometime in December.
Okay.
When I went over there in January to discuss the disqualification motion, that's when I don't receive a phone call. So I don't know when they're turning these restrictions on. I show up and I'm told I can't go in. And that would have been January was the last one regarding the motion to disqualify.
All right. Thanks, Mr. Means. Mr. Wood, I'll ask for your response. And if you would, in the first paragraph of your response, you indicated you don't object to the request to meet in person. So to clarify that, does that mean the state has no objection to him continuing to have access to the attorney-client room if it's available?
Yeah, we don't object to that. We never have. As Mr. Means said himself, he called me one time and I called the jail to help him. He hasn't called me these other times. I didn't even know about it. I didn't know he wasn't able to meet with her. I'm certainly going to address this issue that it coincided with motions we didn't like. I don't tell the jail to not let people see their attorneys. I've never done that. And so I just want to be very, very clear about that. I would never do that. I've never done that. I think even saying that without some evidence is pretty out there. So in terms of meeting, no, we've never had an objection to a meeting with his client, and we don't object to that now. In terms of turning off security cameras, in my response, I know that the jail is able to draw a virtual black box around people. I don't think that we do object to the idea of just turning off security cameras in general. I've never received a request like that from any other attorney. And so we would ask if he can work with the jail to make sure they're not being watched, but to turn off the security cameras is overboard. In terms of the cell phone, Your Honor, that this is I've never seen a request like this. I've never seen another attorney have these issues with their client. The May 9th phone call, this is the first phone call that Mr. Means was made aware of. It was right after she was brought, Mrs. Vallow Daybell was brought to the Madison County Jail. And Mr. Means didn't turn his number into the jail. And so they didn't know to block the number. I turned that number in for him. So if she were to call him again on that number, it's blocked. It's not going to be recorded. On the other 2 days that he's talked about, or the other day that he's talked about, those two calls, they received a warning that they were being recorded. They put him, because of COVID, put him in that attorney or in the general visiting room. The day before, they had told him that he could have it turned off, and it was turned off on March 30th. On March 31st, when he went in and heard that warning, they didn't say anything. So it's not a privileged phone call. By law, it's not. And so now we don't want to listen to their phone calls. I agree with Mr. Means. We don't want their phone calls. It's just working tellmate. It's, again, we haven't had any other attorney make this request. Everyone else has been able to make it work. And I do agree with Mr. Means. COVID is frustrating and difficult. And I do agree he should be able to meet in person with his client. We object to, I think once you give one inmate a cell phone, that's not a slippery slope. You're jumping off a cliff, and everybody else is going to want a cell phone. And I don't know by what grounds you would deny that. So we do object to the cell phone, and to a blanket order to turn off security cameras, we object to that. That's all, Your Honor.
All right. Thank you, Mr. Wood. Mr. Means, any rebuttal argument?
Yeah, just real brief, Your Honor. The black box option, this is the first that this has been brought up to me. I've requested every time that I've gone in there that they turn off the recordings, and I've been told no. I think the black box option, if I could see what the screen looks like, would probably be a reasonable result here instead of turning off the two cameras that are face to face. I worry about, obviously, in the prosecution and the deputies watching the tape, if the camera's right in your face and they can read what you're talking about, there's obviously a violation there. And we know that they've watched the tape. On these recorded phone calls, I think it's important to note that prior to going in on March 30th and March 31st, the deputy and the detention center said, and they put signs out that they have changed the public room to an attorney-client room only, and the recordings were turned off. And so that's a point of clarification that we can probably discuss at a later time. But to have to go in and request that they not record it each time when you're told that they're not recording and they've changed the room is a little a misdirection. I think, again, Your Honor, with COVID, given the history here with, again, and without pointing fingers, recordings have happened. They have been released to deputies. They have been accessed by deputies. They have been accessed by the prosecutor's office. Without getting into that issue, there's still some outstanding discovery on that issue. I think a cell phone extremely limited to only being able to call me at the cost of the defendant would be relevant given the current restrictions that we're under. Now, when the COVID restrictions are lifted and you don't have a client that is handcuffed to a desk that has to speak literally 2 feet to their attorney, 2 feet away from a deputy, I think we can revisit that issue, but I don't think it's a slippery slope given all the exceptions that we're making to accommodate the COVID restrictions right now.
All right. Thank you, Mr. Means.
Your Honor, can I just briefly,
yes.
From my understanding, when there's Mrs. Daybell is allowed to go into a room privately when she speaks over the telmate system with her attorney. That's what the jail has informed me, so that she is not within earshot of a deputy.
All right.
There's no phone in that attorney-client room, Your Honor, that can call out to myself. It is literally at the desk where the deputy is, or at the phone about 10, 15 feet from that desk. So when she's in that attorney-client room, the only phone that there is able to call out to the public access room that you can see in the pictures. So she hasn't been allowed to have a conversation with me other than on those two phones.
Okay. The court has considered the motion then. I'd note that the policies that are implemented in the jails, the court defers to those. There's obviously some precedent out there. I'd cite to State versus Jacobson, 150 Idaho 131. That's a 2010 case that says prison and jail administrators have a compelling interest in establishing necessary regulations and procedures to maintain good order, security, and discipline. And I would note in these times also the safety of the health of both inmates and the jail staff. I've been advised during COVID of the policies that have had to be changed in some respect in order to try to prevent COVID outbreaks from occurring in the jail. And the jail's been pretty successful in doing that here in Madison County. And so I don't substitute my decision-making in terms of some of these access issues for the general policies that are promulgated by the people that are running the jail. However, obviously the inmates are allowed to have privileged attorney-client communications, and that's a paramount right of every incarcerated defendant. In considering the motion, it's made some specific requests, and I'll go through those. The state doesn't object to the use of the attorney-client room. And I do understand, Mr. Means, been in your shoes before and trying to go through a bunch of documents and in particular electronic things on a laptop. You really do need to be able to kind of sit with the client and share that information with them to adequately review that. So there is an attorney-client room in the jail to the extent that's available. I don't know that I need to make a specific order because that's been implemented, but I will make a ruling that subject to the availability of that room without the objection of the state. When you travel here to visit with your client, Mr. Means, you are allowed to use the attorney-client room unless the jail has some overriding policy that on a particular trip, the room's not available. But also considering you're traveling from a long ways away to see your client, that room should be made available, and that's not a special consideration for your client. I would allow that for any client of any attorney that's incarcerated, an attorney traveling where it's a big inconvenience if the room's not available. So I suggest you make a plan with the jail and advise them of when you're going to be there to see if they can sort of, I don't know that they reserve the room, but be advised that the room you'd like to use it, and that will be allowed. The other issues involving the video and the cell phone, in terms of the video, there are security reasons why video should be in place for both attorneys and clients in the jail. The jail sets those policies. I'm not going to make any order that the video be turned off. I'm not aware of this technology Mr. Wood stated is there to potentially black box somebody out so you can't maybe read their lips or see what they're saying. Clearly any audio recordings are not allowed in the attorney-client privileged communications within the jail, since those would violate that privilege if there was audio recordings. I understand it inadvertently happened before in this case, and I just asked the state to make every effort to make sure that that issue doesn't come up again. And then finally, on the request for the cell phone, I'm going to deny that request. I understand why that would be a convenience for you, Mr. Means, but that I think goes way outside of the scope of what the jail policies would be. If the jail came up with a way to allow that right for certain inmates, not exclusive to yours, I'd leave that to them. As the state pointed out, an electronic telecommunication device is considered a major contraband item under Idaho Code 182510, and allowing a particular inmate to have their own personal cell phone is something I'm not prepared to order in this case or any other case, quite frankly. So that part of the request will be denied. So that will be my ruling on the motion for access to the client. Mr. Means, do you have any questions on my ruling?
No, Your Honor. Thank you.
All right, Mr. Wood, do you have any questions or need any clarification on that?
No, Your Honor.
All right, I think that concludes what we had to cover today then, counsel. Is there anything else we need to bring up on this case this morning, Mr. Wood?
No, Your Honor.
All right. Mr. Means, anything further this morning?
No, Your Honor.
Mr. Pryor, do you have anything further?
Nothing further, Judge.
All right, thanks for your attendance, everyone. We will be in recess.
Thank you, Your Honor.